Our second panel today is titled Unions and Religious Schools, a Case Study. It's a discussion centered around Professor Michael Moreland's new paper titled Adjunct Faculty Unionization and Religiously Affiliated Universities. And the moderator for this panel is Sheldon Gilbert. Sheldon is the National Constitution Center's Vice President for Content and Development and a Senior Fellow at the Center. Before joining the NCC, he directed the Institute for Justice's Center for Judicial Engagement. And before that, he was a litigator in the U.S. Chamber of Commerce's Litigation Center, representing the Chamber and clients in over 400 cases before the Supreme Court, other federal courts, and state courts. Sheldon, thanks for joining us today.
Thank you. I was so excited I now have enough of these mugs for our entire family. So that's 4 kids and my wife, so 6 of us. If I come to another one of these conferences, I'm going to start collecting for the in-laws, so thank you. I am so excited to be moderating this panel. This is basically law candy for me, but I want to kind of manage expectations for the audience for how exciting this will be. But I think I can modestly promise that this will be the most exciting panel you have ever listened to on adjunct faculty unionization. Like, this is it. You can go home after this panel. That's going to be our starting point, is adjunct faculty unionization, but we're really talking about something much broader, about the intersection of faith and labor and the administrative state. And for most of us, our labor, our employment, is first and foremost about having the resources we need to care for ourselves and our loved ones. And that makes the stakes pretty high whenever we're talking about labor and employment. But if that weren't high enough stakes, all of us here realize and understand that employment can be about much more than that. It can have even more meaning and even dignity associated with it. This morning I was reading former Texas Supreme Court Justice Don Willett's opinion in a case called Patel versus Texas, and he starts by quoting Frederick Douglass about the first money that he earned as a free man. And Frederick Douglass wrote, "To understand the emotion which swelled my heart as I clasped this money, realizing that I had no master who could take it from me, that it was mine, that my hands were my own, and could earn more of the precious coin. I was not only a free man, but a free working man," right? So labor can have a deep emotional dignitary component to it as well. And if that doesn't raise the stakes enough about labor and employment, add to the mix what we're going to be talking about today, which is religion and faith, right? Whether it's your religious motivations as an employee or as a laborer, as a worker, or whether it's the religious motivations of your employer or your religiously affiliated employer, and with whom you may or may not disagree. And it's that intersection that we're talking about today. And then add on top of that another party to these relationships, which is the government, the administrative state, which raises all sorts of interesting questions that we've been talking about already today, about the proper role of the administrative state in these relationships, these labor and employment relationships. And you get all sorts of fascinating questions that the Supreme Court's been grappling with, right? You have a Muslim woman who wants to work for a department store that wants to prohibit her from wearing a headscarf. What does the administrative state have to say about that? What does the administrative state have to say about a church congregation that wants to fire a teacher that works for the church who has a disability? Should the administrative state have something to say about the congregation's decision to fire a teacher? These are the important questions that this esteemed panel is here to talk about today. On our panel, first, we have Michael Moreland. Michael is the professor of law and religion at Villanova University, or as my 5-year-old calls it, Villain University. She's just started reading, and she was really scared that we live next to the School of Bad Guys when she saw that we're next to Villain University. Michael is the director of the McCullen Center for Law, Religion, and Public Policy, which is doing fantastic work at Villanova. He has been a visiting professor at Notre Dame, and was the Forbes Visiting Fellow at Princeton University in the James Madison program. So first, welcome Michael Moreland as our first guest speaker. We're going to let Michael talk about his paper for a little bit, and then we'll introduce each of the other speakers when it's their turn to react.
Great. Well, thank you, Sheldon, and to my co-panelists for participating in this. Special thanks to Adam White for the invitation to participate in this program, and Leah Davenport and the other staff here, carrying on the mighty work begun by Naomi Rao, this very impressive program at George Mason on the Center for the Administrative State. And I have to say, last year we had the workshop where we presented these papers initially on the opening weekend of the NCAA tournament, and that worked out extremely well for Villanova. And so I'm hopeful that this will also be a good omen for Villanova's prospects this year, where our hopes are not quite as high as they were last year. Anyway, so I'll just read some short excerpts for about 10 minutes or so of the paper to give you kind of an overview of the topics I raise in the paper, and then turn it over to my co-panelists, Greg and Tim, to raise some other issues. The administrative state interacts and regulates religion in many ways, as we know. Religious institutions, particularly large institutions like hospitals and universities, employ thousands of people, triggering several mundane and unobjectionable requirements like payroll taxes, workplace safety regulations, and wage and hour laws. Sometimes this regulation of religion rises to the level of national attention, though, as, for example, with the HHS mandate, which was mentioned on the last panel. But most regulation of religious institutions is less prominent and contentious, while still posing some issues about religious freedom and state interference in the employer-employee relations of religious institutions, as seen prominently, I think, recently in the question of adjunct faculty unionization at religiously affiliated colleges and universities. The conflict over adjunct faculty unionization has waxed and waned over several decades, partly and unsurprisingly on account of the partisan composition of the NLRB, and was the focus of one of the most prominent articles in the field of law and religion over 30 years ago, Doug Laycock's important article on church autonomy and the Catholic bishop case. But more recently, as adjunct faculty seek to unionize and raise objections to their pay levels and working conditions, amid budget problems at both public and private universities, the NLRB has taken an increasingly aggressive position regarding its jurisdiction over collective bargaining at religiously affiliated schools. So let me just provide a little overview again for those new to this area. Some, like my co-panelists, are familiar with this very much so, but others I know less so. So the NLRB, of course, was created by the NLRA, the National Labor Relations Act, in 1935. And for many years following enactment of the NLRB did not exercise jurisdiction over nonprofit educational institutions at all. By the 1970s, however, the NLRB began to broaden its assertion of jurisdiction in new areas and was routinely exercising jurisdiction over educational institutions, including religiously affiliated institutions, with only an exemption for schools that were completely religious and offered instruction only in religious subjects. And I should say, just as a footnote, as many of you probably know, tenured and tenure-track faculty are actually exempt from the NLRB's jurisdiction under the yeshiva precedent because they are deemed quasi-managerial employees. In the landmark case of NLRB versus Catholic Bishop in 1979, though, concerning unionization by parochial school teachers, the Supreme Court held that the doctrine of constitutional avoidance required that the NLRB's jurisdiction not extend to parochial school teachers because there was significant risk of violation of the First Amendment if the board exercised its jurisdiction over church-operated schools, and there was no clear indication of congressional intent in the NLRA to give the NLRB jurisdiction over teachers in church-operated schools. In the absence of a clear expression of Congress's intent to bring teachers in these schools under the jurisdiction of the board, the court wrote, "We decline to construe the act in a manner that would call upon the court to resolve difficult and sensitive questions arising out of the guarantees of the First Amendment religion clauses." Since Catholic bishops, courts have expanded the holding of the case to cover a broad range of religiously affiliated schools, not merely those that are church-operated and not merely primary and secondary schools. The core of these courts' concerns is that the same line-drawing exercise that would be required should the NLRA be interpreted to apply to religious schools, whether elementary and high schools or colleges and universities. And I'm happy to talk about the line of precedence with regard to that. But the NLRB pushed back against this position of the courts, and for several years adopted a test that Catholic bishop was limited only to schools within the board's parlance substantial religious character, and that the board should determine on a case-by-case basis whether a school has such a character. And in order to make this determination, the court, in one opinion, said it considers such factors as the involvement of the religious institution in the daily operation of the schools, the degree to which the school has a religious mission and curriculum, and whether religious criteria are used for appointment and evaluation of faculty. The substantial religious character test resulted, of course, in a much narrower range of schools being exempted from board jurisdiction over faculty collective bargaining efforts, thus requiring those schools that resisted such jurisdiction to appeal the board's rulings in federal court. And then the next kind of pivot point was a 2002 opinion from the D.C. Circuit, in which the D.C. Circuit held that the NLRB's determination of a school's overall religious character was an inappropriate way to make such jurisdictional determinations. The D.C. Circuit instead, in the Great Falls case, articulated a three-pronged test to determine whether a religious institution was exempt from the board's jurisdiction, and again, implementing what the D.C. Circuit held to be the line of precedent coming out of Catholic Bishop. And the Great Falls test was a simple three-part test that the institution holds itself out to students, faculty, and the community as providing a religious educational environment. The institution is organized as a nonprofit, and the institution is affiliated with or owned, operated, or controlled directly or indirectly by a recognized religious organization or with an entity membership of which is determined at least in part with reference to religion. As the D.C. Circuit explained in that opinion, the Great Falls test allows the board to determine whether it has jurisdiction without delving into matters of religious doctrine or motive and without coercing an educational institution into altering its religious mission to meet regulatory demands. Carry this story forward a few years, especially the last decade or so, there were a series of cases in which there was once again a revisiting this question of NLRB jurisdiction, and several religiously affiliated schools, notably St. Xavier in Chicago, Manhattan College, Duquesne University in Pittsburgh, resisted claims to NLRB jurisdiction. Now, in each case, of course, the schools clearly satisfied the test in Great Falls, but again, the board fell back on its substantially religious character determination to assess its own jurisdiction. And so this most recent round of arguments reached a culmination in the board's 2014 decision in the Pacific Lutheran case. There, the board departed from its previous and longstanding substantial religious character test, but refused to adopt a test as deferential as the D.C. Circuit's Great Falls approach. Instead, for the board to decline jurisdiction in case it will first impose a threshold requirement asking whether the university, in fact, holds itself out to students, faculty, and the community as providing an educational environment. But then the second step, the board will impose a requirement that the university holds out its petition for faculty members as performing a specific role in creating and maintaining the religious educational environment, a requirement that in that case Pacific Lutheran could not meet. And I'll just say a few things about the Pacific Lutheran test, what I see as some of its shortcomings, and then turn it over to my co-panelists. One concern, I think, about the Pacific Lutheran holding, and I should say that under the board's new composition, there's been some opening to revisiting the Pacific Lutheran holding, but one concern is that the board has a remarkably cramped account of whether faculty contribute to the religious mission of a university. The board holds that where a school does not indicate that faculty members are expected to incorporate religion into their teaching or research, that faculty members will have any religious requirements imposed on them, or that the religious nature of the university will have any impact at all on their employment, then in those instances, the university is not holding out its faculty as performing a religious function. More troubling, I think, is the board's claim that this is, and this is a quote from the Pacific Lutheran case, this is especially true when the university also asserts a commitment to diversity and academic freedom, further putting forth the message that religion has no bearing on faculty members' job duties or responsibilities. The Pacific Lutheran approach, while trying to be more accommodating to the objections of religious schools by shifting from an institutional inquiry to a faculty role inquiry, still contains, I think, a good deal of judgments about what kinds of institutional settings are sufficiently religious and which are not. Indeed, the whole problem with the holding out faculty test from Pacific Lutheran is that it throws the board right back into the intrusive religious inquiry that courts from the U.S. Supreme Court and Catholic Bishop to the D.C. Circuit in Great Falls and other cases have said runs a high risk of unconstitutional interference with religion. On the board's view, only when faculty engage in religious indoctrination or training or where a school imposes a narrow religious test for hiring would the board decline jurisdiction. But this is the board's own view of what counts as factors sufficient for faculty at a school to be part of its religious mission, a view not shared by Pacific Lutheran, or indeed I think most Catholic universities. And so I think in its opinion, the board begs the question by asserting its own, indeed highly contestable view of what constitutes the religious mission of a university, including a rejection of academic freedom and curricular and hiring practices in which very few universities engage. And so the end of the paper, I discuss how this raises a whole set of, I think, broader issues, which again, I think my co-panelists will raise about kind of the way in which the NLRB's test, as it's been shaped over the years, I think has some interesting implications with regard to employer-employee relations in other kinds of contexts, the ways in which the board's test shapes the mission of different kinds of religious institutions. We can talk about, I think, what some, I think, quite genuine concerns on the parts of the universities about the ways in which the mission would be implicated by the board exercising its jurisdiction. But I think I'll end there and look forward to the conversation with my co-panelists and questions from the audience.
Thank you. First, we get a round of applause for Michael. We're gonna next go skip over Greg, and we're gonna go to Tim. Tim is the Deputy Assistant Secretary for Policy at the U.S. Department of Labor. Now, Tim is at a different labor regulating agency than the one that Michael was just talking about, the National Labor Relations Board. So Tim is going to exercise his prerogative to not talk about the National Labor Relations Board pretty much at all, and focus on what you see as the issues that you're seeing kind of from your perch at the Department of Labor in this area outside of the National Labor Relations Act context.
Sure, and thanks, Sheldon, and thanks to George Mason for the opportunity to speak today. And as Sheldon just said, I'm at the Department of Labor, so I can't opine, and I'm not opining on how these questions of religion in the administrative state are handled by the NLRB or the EEOC or any other agency. But I want to put forward, from my perspective of the Department of Labor, 3 principles that we use when these sorts of issues arise. So the first principle is this. The Department of Labor adheres to the Trump administration's policies on religion. And President Trump has issued 2 key executive orders on the subject, one in May 2017 and one in May 2018. And I'll share just a couple excerpts from both. Excuse me. So from the first one, it states this in part, in the first section. It says, "It shall be the policy of the executive branch to vigorously enforce federal law's robust protections for religious freedom." Period, full stop. And then from the second executive order, "The executive branch wants faith-based and community organizations to the fullest opportunity permitted by law to compete on a level playing field for grants, contracts, programs, and other federal funding opportunities." So there's a little bit on sort of the general overview from the Trump administration in its treatment of religious organizations. Now for the second principle. The Department of Labor seeks to ensure that its policies comply with Supreme Court precedent interpreting the religion clauses of the First Amendment, the Religious Freedom Restoration Act, and other relevant and applicable federal law. And 3 recent decisions here are particularly relevant when considering the question of how government should regulate or not regulate religious organizations. So the first of these decisions is Hobby Lobby, which we've already discussed a little bit today, and I'm assuming most people here are familiar with it. And I just want to pull out a few quotes from the case that are really relevant in this area. And here they are. So quote 1, "The exercise of religion involves not only belief and profession, but the performance of or abstention from physical acts that are engaged in for religious reasons. Business practices that are compelled or limited by the tenets of a religious doctrine fall comfortably within that definition." Another quote, "Furthering their religious freedom, meaning the freedom of for-profit and nonprofit corporations, also furthers individual religious freedom." And finally, a third quote, "It is not for us to say that the organization's religious beliefs are mistaken or insubstantial. Instead, our narrow function in this context is to determine whether the line drawn reflects an honest conviction." A second Supreme Court case in this area that we find important. And this is the Trinity Lutheran case, the preschool playground resurfacing case, and whether they could get a grant from the Missouri government. A couple quotes here. Quote 1, "Denying a generally available benefit solely on account of religious identity imposes a penalty on the free exercise of religion that can be justified only by a state interest of the highest order. And a second quote, the exclusion of Trinity Lutheran from a public benefit for which it is otherwise qualified solely because it is a church is odious to our Constitution and cannot stand. And finally, a couple quotes from Masterpiece Cake Shop, which we've also heard quite a bit about it already. So the first quote is this: "The government, if it is to respect the Constitution's guarantee of free exercise, cannot impose regulations that are hostile to the religious beliefs of affected citizens and cannot act in a manner that passes judgment upon or presupposes the illegitimacy of religious beliefs and practices." And then secondly, "The Constitution commits government itself to religious tolerance, and upon even slight suspicion that proposals for state intervention stem from animosity to religion or distrust of its practices, all officials must pause to remember their own high duty to the Constitution and to the rights it secures." So that was the second principle, is adherence to these Supreme Court decisions, among others. And finally, a third principle that we apply, which is this: the Department of Labor carefully assesses how to prevent excessive entanglement with religion without compromising its agency's critical mission of protecting America's workforce and promoting job creation. So let me give you just a couple examples of how this actually works in practice in concrete terms. So the first of these comes from one of our agencies called the Office of Federal Contract Compliance Programs, or OFCCP. OFCCP is charged with enforcing federal contractors' obligation to provide equal employment opportunity, regardless of race, color, religion, sex, sexual orientation, gender identity, national origin, disability, or veteran status, among other things. Now, the agency is committed to vigorous and fair enforcement, and our statistics will show that. Yet there are still specific exceptions for religious organizations. Certain non-discrimination requirements do not apply to, do not apply to religious organizations, quote, with respect to the employment of individuals of a particular religion. And Title VII contains a very similar exemption for religious organizations, and courts have interpreted the exemption in that context in this way. They've said the permission to employ persons of a particular religion includes permission to employ only persons whose beliefs and conduct are consistent with the religious employer's religious precepts. And OFCCP recently issued a guidance document to its own staff. It's Directive 2018-03. You can find it online, noting this exemption and stating the following, among other things. OFCCP staff should bear in mind that they cannot act in a manner that passes judgment upon or presupposes the illegitimacy of religious beliefs and practices, and must proceed in a manner neutral toward and tolerant of religious beliefs. They cannot condition the availability of opportunities upon a recipient's willingness to surrender his or her religiously impelled status, and they must permit faith-based and community organizations to the fullest opportunity permitted by law to compete on a level playing field for federal contracts. And again, some of that language is from these other authorities that we've already discussed. Let me give you a second example. This comes from our Wage and Hour Division. And the Wage and Hour Division is one of our largest divisions. It enforces, among other laws, the Fair Labor Standards Act, which includes things like the minimum wage, overtime requirements, child labor requirements, all very important things. Yet once again, in this context, the department respects the rights of religious organizations. For instance, the division recently issued an opinion letter. The Wage and Hour Division has a practice of issuing these guidance documents called opinion letters. Employers can write into the department representing facts and asking basically for an opinion as to whether their practices comply with the Fair Labor Standards Act, the Family Medical Leave Act, or other laws. And then in the department's discretion, it can write back and explain its view on that. The division recently issued an opinion letter addressing whether the Fair Labor Standards Act applies to certain members of a communal religious organization, and this was issued in December 2018. According to the group's request for the opinion letter, the group aims to emulate the early Christian communities described in the Book of Acts by dedicating themselves to sharing in a community of goods. And the members hold as a religious tenet that work is indivisible from prayer and a form of worship, and that they have their basic needs met, not as a right or in proportion to services rendered, but according to need. So, an interesting situation. And the opinion letter responded and noted in relevant part that the Wage and Hour Division has had a long-standing recognition in its own internal guidance and practices in its manuals that persons such as nuns, monks, priests, lay brothers, ministers, deacons, and other members of religious orders who serve pursuant to their religious obligations in the schools, hospitals, and other institutions operated by their church or religious order shall not be considered to be employees as defined under the Fair Labor Standards Act. And so the opinion letter reasoned that this policy, which itself is a recognition of the ministerial exception required by the First Amendment, applied to the members of this religious community. And so the opinion letter explained in relevant part here, this. It said, given the egalitarian relationships among the members, it is difficult to distinguish them from the nuns, monks, and others who believe themselves called to lead lives of service and are exempted from the FLSA. Imposing the FLSA on these members and their community would force them to recognize private property, wages, and hierarchical economic relationships among members, vitiating their central religious beliefs. And then quoting from the Seventh Circuit, the vow of poverty is a hallowed religious observance, and intent to destroy it cannot reasonably be ascribed to the draftsman of the Fair Labor Standards Act. So those are a couple examples of how the Department of Labor is vigorously enforcing the law while also recognizing the protections of the First Amendment and other federal law. And in closing, the department has no desire to entangle itself in what should remain solely religious matters, and it recognizes religious organizations as full members of the American community.
Thank you. And finally, Greg Lipper. Greg is a partner at Clinton and Peed, and before that, he spent many years as a litigator for Americans United for separation of church and state, and has been involved in many of the cases that we've been talking about throughout the conference today. Greg.
Thank you. So I want to start with three brief reactions to Michael's paper. The first thing is, and I think this is kind of keying off on a lot of what Professor Epps said at the previous panel, that the paper, I think, frames this issue as the NLRB versus religiously affiliated universities. And that is certainly one way to frame it, and that may be the way that, the case caption reads. But there's another really important interest at stake here, and that is the rights of the employees who are affected, by the decision as to whether or not they have the right to unionize. And, I think there are two strains of that. One is just they have their own associational rights to collectively bargain. And then number two, there is the practical implications of that ability to collectively bargain on their wages, on their working conditions, on a host of other things. And sort of their protections as workers, their ability to associate with other workers, the tangible impacts on take-home pay and other benefits are significant. And what we can describe it, I may not describe it in quite as soaring terms as Sheldon did or as Frederick Douglass did, but those are real and weighty interests, both practical, monetary, and associational. And those, I think, have to be part of the discussion. And the broader the exemption from those rules are, the broader number of workers are affected, and the broader number of workers are deprived of important rights that most other employees are entitled to by law. And again, you can say, well, look, you signed up for it. If you want to teach at a particular institution that is religiously affiliated, then you are kind of doing this with your eyes open. But again, I think there are limits to that. I think it's one thing, if you sign up to work at the archdiocese, as one of my cousins used to, then that's one thing. But if you're, say, a Buddhist who wants a job as an adjunct professor of mathematics, teaching freshman calculus to engineering majors at the University of Notre Dame, it seems like that bargain is different. And the expectation that you are sort of relieved of the protections of important bedrock workers' rights laws, I think is much more debatable. So that's point number one. Point number two is the flip side of that, and I think a lot of what's driving Michael's paper is concerns about entanglement, that once we allow this line drawing or any sort of line drawing, either about the character of the institution itself or the characters of the affected faculty members, we are sort of immediately down the path where the government officials and ultimately the courts are serving as sort of theologians. And obviously, entanglement concerns are real, and government officials should not be making religious or theological determinations. But in practice, there is middle ground, and it's middle ground that we're actually used to in a number of areas, that government officials and courts do, and in fact have to, make determinations all the time about whether particular activities or particular conduct is or isn't religious. I mean, just as a very basic example, the religion clauses of the Constitution require to enforce them, you have to make a determination as to whether the activity at issue is religious or not. So that if I'm in prison and I assert a Arlupa claim based on my membership, my membership in the Animal Legal Defense Fund, I'm going to very quickly get a court decision saying, sorry, that's not actually religious. And so, and that's just a basic example. But, it gets more than that. I mean, we saw this in the sort of canonical case of the ministerial exception in Hosanna Tabor, where on the one hand, there is this very broad right that the government cannot interfere with religious institutions' hiring and firing of their ministers. Unanimous Supreme Court decision on that point. On the other hand, not everyone is a minister, and courts ultimately have to determine that. And there was a lot of questions at the oral argument from not only the court's more liberal members, but from even people like the Chief Justice, who were like, how do we determine who's a minister? And I think most of us anyway agree that a church or a synagogue cannot simply say, well, our custodian is actually a minister of facilities, and by keeping our facilities clean, it's a precondition for all the other worship. Therefore, that person's a minister, and we can hire and fire that person on the basis of race. Like, that argument's going to get laughed out of court, and I think properly so. But implicit in that is a determination about, is that person's job sufficiently ministerial? There are hard questions. There's line drawing. We still don't. As far as I'm aware, there's not any decisions saying that, for instance, a math teacher is a minister because they contribute to the educational mission of the religious school. And so, again, these are lines that have to be drawn. And the same thing with institutions. That there are many instances in the law. There's a bunch in the tax code, for instance, treating houses of worship differently from institutions that are religiously affiliated but that aren't houses of worship themselves, like religious hospitals, religious schools. And again, I think that's important not just for sort of maintenance of an appropriate line between civil society and religion, but also, and this is a point Professor Laycock made in a brief in the second contraception case, that if the law is such that any accommodation granted to a house of worship also has to be granted to everyone on down to like the University of Notre Dame, not to keep picking on Professor Munoz's school, that's gonna really shrink the number of religious accommodations are available, because just society is not gonna be able to function that way. And so, Professor Laycock, who never before in his career had filed a brief opposing a request for religious accommodation, said, treating all religiously affiliated institutions the same as houses of worship poses a mortal threat to religious liberty. Like, this is not a guy who likes narrow religious exemptions, but he was terrified of the inability to draw lines. And there was even questions at the Zubik argument, from Justice Kennedy, for instance, to the now Solicitor General, but then Representative Flores. Like, I can't write an opinion saying I have to treat everyone the same as houses of worship. And I think that's the same thing, that line drawing is tricky. Courts need to draw those lines with sensitivity to as not be making theological determinations, but ultimately courts and other government officials can and in fact must be able to distinguish between different types of organizations. The third point I want to make, it's not something Michael talked about so much in his remarks, but there's an interesting discussion in his paper sort of grappling with what exactly is the religious interest in not having any unionized employees. And it is counterintuitive. I mean, especially as he notes in the paper, for instance, the Catholic Church was very supportive of the union interests in the recent Janus case. I think filed a brief, held a press conference afterwards. They seem to be a pretty pro-union crowd. And what are their concerns here? And something that's discussed in the paper is sort of, and Catholic Church and other religious entities of sort of, we have certain religious beliefs about how disputes should be resolved, and they should be resolved more collaboratively, without this sort of the state or, sort of the union kind of hanging over our heads. And I think that may be accurate as a descriptive matter. I think, though, that is a type of interest that I think courts and other government officials have to be very, very careful about, because there's the first of all the practical point that when you're dealing with employers and employees, there's just you have very unequal bargaining power here, so it's not this sort of stylized collaborative consensus environment. But beyond that. That type of argument can have a lot of serious implications. They were touched on in Hosanna Tabor, where obviously the teacher in that case was fired because she went to the EEOC, and that was deemed a violation of the church's tenets about the way disputes should be resolved. And the court upheld it in that case in the context of anti-discrimination laws. But there was a lot of questions at oral argument about, are you saying that you could fire a minister for going to OSHA and reporting a serious health and safety hazard? Or can you fire someone for, say, testifying before a grand jury about allegations of sex abuse in a church? Those questions were sort of not addressed in the opinion. There's a blurb at the end of the opinion by the Chief Justice saying, well, the church says this isn't really a concern, and the plaintiffs and the EEOC say this really is concern, and we don't have to resolve those things here. But I think the logic of, well, anything that interferes with our sort of more informal collaborative decision-making and resolution of problems needs to be treated as sort of this, needs to be really getting a lot of deference, I think, is very troubling, because it runs headlong into just the rule of law, that in a ultimately society based on law that is secular, there has to be mechanisms for certain disputes to be resolved by the proper authorities, by the law. And so I would say, not to say that interest never gets taken into account, but it is I think should be treated very carefully. The final thing with that is too, that can implicate a broader swath of concerns. I mean, Michael said, mundane and unobjectionable rules governing, I think you talked about things like worker pay and the like, but those mundane and unobjectionable things have all been the subject of big free exercise decisions. There was a free exercise challenge to Social Security withholding requirements that was rejected by the Supreme Court. There was a free exercise challenge to minimum wage and overtime laws that was rejected by the Supreme Court. There was a free exercise challenge to laws requiring men and women to be paid equally that was rejected by the Fourth Circuit. And so at the point where any disputes about working conditions or have to be resolved internally, and that any outside regulation of that is a free exercise violation, has rather staggering implications, and all of the worker regulations that I think should be mundane and unobjectionable cease to be so.
Thank you, Greg. I would love to get some questions from the audience. If not, I've got a bunch of questions that I would love to ask. But we've got a lot of interesting issues. Do we have, Helen, do you have a microphone?
Now you have two.
An embarrassment of microphone riches.
So one of the questions that's interesting, but also overlaps entanglement, I'm working on this now, which is why I have these sources to hand, but there's a lot of, sociology of religion sources that talk about how faith actually gets passed on in religious institutions. And it turns out, Pache, all the deacons, sisters, ministers, priests, rabbis, it's usually not the designated minister. It's usually other people. It's family, and it's people in that environment that someone is motivated to say, wow, I really like the way they live. They profess this religion. I think it's possible to live this way. I think it's a good way to live. And which means, if this is true, that institutions would have to say, listen, the custodian's not doing this, but the math teacher is, because when he teaches calculus, he weeps about the beauty of the universe God has made. And so we're going to go with the math teacher as a minister, but not the custodian. And yet it involves entanglement. It's just, because of how religion is actually passed on, I just think Hosanna Tabor could not be limited to its functional analysis. That's for both Greg and Michael, most likely. Okay.
I mean, I think it's a nice way of putting a frame on, I think, some, I mean, Greg is a great interlocutor and critic on these issues. and especially, I think he's right to point out that in the administrative process, in litigation, there's always this question of, who counts as a minister, what's actually a religious institution. I guess the point I would come back to, and I think here I'm following Helen's lead, is that I do think that the better approach, the normatively better approach, is one that's more deferential, within bounded limits, obviously, but that is more deferential, as the Justice Alito and Justice Kagan's concurrence, for example, in Hosanna Tabor argued with regard to the definition of who counts as a minister, and as, to bring it back to this, as the Great Falls test, I think, underscored with regard to adjunct faculty unionization. And there's also a larger issue here, and it gets also into some of the questions about, Catholic institutions and seeming, being at odds with other aspects of the church's doctrine on unionization, all that. But I also think another way into that question is to observe that the debate about religious freedom is often inflected, I think, by highly kind of individualist claims of conscience. I mean, it even came up on the last panel. And Yuval Levin made a point about this during the Hobby Lobby controversy too, that the kind of Lockean letter on toleration, individual claims of conscience, has a heavily kind of Protestant tint to it. In the Catholic context, of course, a lot of Catholic institutions tend to be much bigger. They're like Notre Dame, right? They have thousands of employees, thousands of students, hospital systems that are massive. And I guess I want to make a plea for arguing that just by virtue of being larger with more employees, that doesn't mean that somehow the rights of integrated autonomy within those institutions somehow starts to ebb away, at least as dramatically as I think Greg might think they do. So those are just kind of two reactions to that.
That's fair. I think one thing I do want to point out, though, about that is that I think Pacific Lutheran is deferential in this sense, that a lot of what they were basing their standards on was, how do you, the college or university, describe the position, right? So if you are hiring your adjunct math professors and not imposing any religious requirements on the position and describing the position in purely mathematical terms, and not saying that you have to be a Catholic who can, when teaching derivatives and integrals, also weep about the beauty of the universe. Like, if those aren't requirements, then you don't get to turn around and say, but actually, these folks are also integral to our religious mission and can't unionize. So I think there is a certain logic to that. It's sort of like it's like putting your mouth where your money is in a way. Like, you know, and if you want to advertise the position as, you know, with a lot of religious, you know, we want our calculus teachers to have these religious beliefs and have these religious tools and use them in the classroom, then fine. But you need to own up to that in how you're advertising the position. And I think that's important because, you know, I think, you know, I keep picking on Notre Dame, not just because of its size and not just because I litigated against them at my previous job, but, and not just because, you know, my school hates their school's football team, but, I mean, all of those things are true, but really, I mean, Notre Dame, for instance, like, Notre Dame positions itself, and it's not the only one, positions itself not just, you know, as a religious school, but also as sort of this prominent national research institution that has a diverse faculty and diverse students, that like it has, you know, if a school is making a choice that like we want whatever benefits come from from casting a wider net of calculus professors, then I think to then turn around and say, once you're in the net, but now we're going to treat you like ministers, I think that's troublesome. And so in that sense, the Pacific Lutheran approach is just like, we're just going to look at how you describe the position. And if you describe it in religious terms, then fine. But if you're not willing to do that when hiring or defining the position, then you don't get to turn around and like claim that person as a minister once they're in the door.
Michael, to what extent do you think, you know, Greg has suggested this tension between an entity, a university that's trying to establish a national identity that is compatible with kind of the norms of academia writ large in society, and there might be trade-offs that are associated with that you have to give up some of your religious identity to do this. To what extent do you think these other institutions, like accreditation and everything else, that are kind of driving the way that universities describe their positions and recruit faculty, do you feel like universities are stuck between kind of a Scylla and Charybdis? Are they giving up some of their religious, or being asked to give up some of their religious identity to fit in with kind of the broader norms and expectations of universities? And what do you think of that trade-off?
I think a lot of it depends on, you know, the particularities of the institution and the position. Here, I'm you know, agreeing with Greg that, I mean, there should be clarity about the institution's mission and about what is expected of faculty and employees more generally. I guess on one point, though, where your point about, you know, sort of academic ambition and accreditation and so forth, I think where it runs up into problems in the Pacific Lutheran context, I think the weakest part of the kind of justification that the board offers in Pacific Lutheran is where it says that, well, if you accord your faculty academic freedom, then and sort of don't hold them to, you know, to being disciplined for any kinds of departure from religious doctrine and so forth, well, that means that you're not serious about these faculty then being you know, being part of the mission. It just seems to me that again, the board is substituting its own view of the trade-off there, right? That somehow those of us who teach at Catholic universities and have tenure, thank you, you know, that somehow that by virtue of the fact that we have academic freedom and contractual protections for tenure and all that, that somehow now the religious mission of the university has, again, has kind of dried up with regard to that. And those trade-offs, at least I think in the Catholic higher education context, just aren't the way that the question is framed. And again, I resist the board's effort to kind of say that it has to be otherwise.
Looks like we have a couple questions in that middle row.
So, do you think that some of the issues that you're seeing here are a similar issue to sort of the court's analysis of the sincerity test under RFRA, that they're trying to make a distinction between, do you sincerely hold this religious belief or do you not? But a lot of times judges misinterpret that or push that a little bit too far into an orthodoxy test. Instead of, do you sincerely believe this? They turn it into, should you believe this? Or does the religion that you claim to be taking your actions on the basis of believe that? And so they meld the sincerity test into an impermissible theological analysis. And because it sounds like the distinction between you needing to be consistent in how you view your professors, if you require your math professor to follow the teachings of the church in one regard, then you have to do it in the other regard. That's sort of looking at, are you actually saying you believe that this position needs to be ministerial as a sincerity value, but as Mr. Moreland's description, where the board kind of changes the views of, they're adding a theological interpretation to distinctions that may not really be there, if that makes sense.
That's a good question. And Greg, just to put a point on your last point, you remarked on kind of the tension between Catholic social teaching about unionizing and these Catholic institutions that are blocking unionizing. Is that, in a way, kind of a sincerity test? Ought there be a piece of that? Should we be asking what the motivation of one of these universities is not to unionize?
Right. So I actually don't think the tension there is necessarily relevant. It was sort of an interesting part of the paper. I don't know that necessarily. I mean, let me say this. Sincerity to me is sort of a threshold question. Like, do you sincerely believe this? If you don't, then like we're done. I have parenthetically, after sort of Hobby Lobby and whatever we can make out of Zubik, where sort of anything could be, my signing of form is a substantial burden. I think that's going to put more pressure on sincerity analysis, given that there are potentially other non-religious motivations for raising these objections. And if substantial burden isn't doing any work at all, that's going to put more pressure on the sincerity element. So, but I think what I'm saying here is not that. I'm assuming that everyone's sincere. I guess what I'm saying is that when you're dealing with sort of, we're ultimately balancing between two sets of rights. We're balancing between the university's rights to sort of structure their affairs exactly how they want, and then we're dealing with the workers' rights to be protected under a generally applicable law that's available to others. And necessarily there have to be decisions as to, we recognize there has to be a religious exemption for some entities with respect to some workers. And then the question is which entities and which workers. And there I think you have to look at all of those things in just deciding which entities and which workers. So I don't view that as a sincerity analysis. I mean, again, if it's going to be all entities and all workers, that is going to put more pressure on sincerity. Then we're going to look, are you actually doing this because you have an objection to non-collaborative decision-making, or are you doing this because it's cheaper, right? And, and there is obviously, there may well be an economic incentive. So, but what I'm saying now is assuming sincerity, there still has to be the mediation between the rights of these two groups of people, and you have to look at sort of how the university holds itself out, what it does, and how it describes the positions in determining sort of who's covered and who's not.
I guess I'll just say that I knew Greg was going to talk about Hobby Lobby there, because it does seem that the doctrinal structure around these issues of sincerity, going back to cases like Thomas versus Review Board, did the religion really preclude him from working in the munitions factory? And then continuing on through Hobby Lobby it seems to me quite sound. There's pressure on it, I think, from some skeptics, right, saying that the so-called, kind of complicity arguments that people have been criticizing, saying that, well, then this risks going too far. But I think that the basic doctrine there is right.
Okay. Maybe this question will bring Mr. Taylor back into it, because it's primarily for him, although I don't want to hear from everyone else too. We've been discussing Trinity Lutheran and other, equal access type cases. There's a case out there that seems to me, I'm talking about Locke v. Davey, that seems to me to run counter to both preceding and succeeding equal access cases. The defense of it is, oh, well, he was going to use the scholarship money to be a minister, but that was also the case in Witters versus Department for the Blind. And unless they were interested in overruling Witters, that should not have been a factor. I guess let know from Mr. Taylor whether he has any thoughts on that, and then anyone else.
Sure. So, Locke v. Davie was addressed at length in Trinity Lutheran. It reminds me a little bit of a phrase that I heard from law school from my favorite professors, where he would describe the odd case here and there as an aardvark. He would say, here's your line of consistent case law, and then here's the aardvark. So I'm not sure how completely reconcilable Locke v. Davie is with Trinity Lutheran and the rest of it. I think they took a swing at it in Trinity Lutheran.
No pun intended.
But if anything, I think that the theological valence in Locke v. Davie was even closer, right? Where every possible establishment clause type of issue was lit up, right? Where it's directly for a theology degree, which gets about as close as you can get to a possible establishment clause violation. So I think just in terms of whether there's a completely consistent doctrinal structure behind that, in terms of just sort of the gut feel of it, Locke v. Davie seems different. So that's my take on Locke v. Davie.
And I would say, I agree with that in terms, certainly in distinguishing Locke v. Davie from Trinity Lutheran. But I would say more broadly, the phrase in Locke v. Davie is kind of there's play in the joints, right? That the free exercise does not require the government to do everything the Establishment Clause permits. And the corollary to that is the Establishment Clause does not prohibit everything that the Free Exercise Clause does not require. And that's why we have, for instance, a fairly broad scheme of religious exemptions in the form of RFRA, ARLUPA, Title VII, whatnot, that certainly preference religion, but are deemed, there's debate around the margins, but generally speaking, are sort of acceptable and welcome accommodations of religious belief and practice in a diverse society. I think the one thing that's a little troubling about a case like Trinity Lutheran or forget the name of the case out of New Jersey that was in which cert was denied, but there was a pretty vigorous dissent from that denial, is that it seems like the courts, or at least the High Court, is moving in a direction where, on the one hand, we have maximum accommodations. So religion is treated quite non-neutrally when it comes to religious accommodations. But on the other hand, when it comes to government funding, all of a sudden, religious institutions have to be treated exactly the same in terms of eligibility for federal dollars as non-religious institutions. And if you put those things together, then it's like the government cannot, I have to give you religious institution money for this government program, and then I have to let you, then I have to give you an exemption from, say, anti-discrimination laws that will actually affect how you use the grant money I give you. And so I think, play in the joints makes sense to me, but there's got to sort of, the play has to be the same in each of the two joints. And if there's a lot of play in the accommodations joint, but no play in the sort of withholding joint, then I think sort of things get quite out of whack, and you have no real church-state separation.
I mean, it's a fascinating question it's what keeps people who teach First Amendment like me in business, right, is that we have to kind of help students kind of work through all this. I would have said 3 or 4 years ago that the reconciliation of, or the way of accommodating or understanding Locke v. Davie in the mind of Chief Justice Rehnquist was that, along with Zellman, it illustrated ways in which was the school voucher case, that the states had some play with regard to their ability to raise or lower Establishment Clause bars, so that Ohio can have vouchers for parochial schools, or parents who make the choice to send their kids to parochial schools. Washington can say no funding for ministerial education. I do think that Trinity Lutheran then comes in. I think that it means that the scope of Locke v. Davie really does become very narrowly focused on ministerial education, full stop. But as you say, Witters is somewhat at odds with that.
I think we've got time for one last question.
Just a quickie. wouldn't you understand with Trinity Lutheran that what we're seeing now is the adoption of Scalia's dissent in Locke versus Davey? I mean, Rehnquist did this as a problem of federalism, that the states, and Byron White accepted the same thing too, that a state could fund religion and could refuse entirely to fund religion. But the line here is in, remember the old Zobrist case about the deaf student who was then deprived of his interpreter simply because he entered the Sal Ponte Catholic school? It seemed to be a disability that depended solely on religion. Now, it's not a matter of free exercise. I mean, the people who are no interference with the freedom to worship on the part of people who denied the surface for their playground. It wasn't really an establishment of religion. It was something different. It was a disability based solely on your religious affiliation. Is it your sense now that Scalia's dissent in Locke versus Davey is really the view that has taken hold about both and all sides of the court?
The only, I'd have to look back to refresh my recollection in every detail, but there are passages in that dissent in Locke versus Davey where Justice Scalia, I think joined by Justice Thomas, makes points about just kind of a almost Philip Kurland-esque rule of kind of neutrality almost, which can't be the case precisely because, as Greg says, we have widespread accommodation, right? So it can't be that, so there has to be an ability of government to accommodate religion, and that can't, which any kind of strict formal rule of neutrality would say you can't allow for. But again, I think I'd have to look back at the dissent to remember just how sort of, robust those passages were.
Yeah, and I mean, I do think Justice Sotomayor's dissent in Trinity Lutheran expresses, in my view, a lot of the right concerns because, I mean, on the one hand, yeah, it's just a playground, but it's really like the government's paying to like build a church. And, the church had many opportunities in that case to say, we're not going to use the playground for religious worship, and they refused to do that. As is their right, they should do whatever they want on their playground. But if we have on the one hand Hosanna Tabor, which says like, this is a house of worship, the government doesn't get to pick the ministers. But on the other hand, it's like, well, this is a house of worship, the government has to pay for the building of it. That is, I think, when things are getting a little out of sorts.
Well, thank you. Can we give a round of applause for our wonderful panel?